Something has happened to lawfare in the last 5 or 6 years is that now countries engage in lawfare. And there's a lot of litigation going on where countries, including Canada, are taking cases that are really just occasions to litigate human rights issues. Canada last year filed a case against Syria. And Canada is intervening in the case in Ukraine, and it's intervening in the case against Myanmar. And surprised if it intervenes in the case against Israel as well, although probably not to support the applicant in that case. We shall see. I'll tell you a little bit more about that in a minute. This case that was filed at the end of December, so it was just 3-4 weeks ago that it was actually filed at the court, is based on the Genocide Convention. It's the 17th case to be filed at the International Court of Justice based on the Genocide Convention. And just to put that in perspective, there have been about 190 cases filed at the International Court of Justice since it began in 1946. So we're talking about almost 10% of the cases. And to that, we have to add two what are called counterclaims, where the respondent sues the applicant back. And we have an advisory opinion of the International Court of Justice on the Genocide Convention as well. So it's been a huge source of litigation at the court. All of these 17 cases are based on what we call a compromissory clause in international law, which is a clause in a treaty that gives the International Court of Justice jurisdiction over the treaty, but not general jurisdiction over the country for other matters. About, I think, 70 countries now have accepted the jurisdiction of the International Court of Justice generally, and that's not even a majority of the member states of the United Nations, 193 member states. Of those that have ratified the Genocide Convention without a reservation to the compromissory clause, there are about 15 who've done that. We're left with approximately 140 countries who've accepted the jurisdiction of the court over the Genocide Convention. The Genocide Convention, adopted in 1948, is the first human rights treaty within the United Nations, really the first human rights treaty ever. It was adopted, of course, in the aftermath of the Second World War, very much in parallel with the Universal Declaration of Human Rights. And a month ago, we marked the 75th anniversary of its adoption on the 9th of December, 1948. Canada ratified it in 1952, I think, 1952 or 53, quite early, because other countries, the UK didn't ratify it until 1969. The United States didn't ratify it until 1988. So we've got 140 countries who are susceptible to being sued at the International Court of Justice based on the Genocide Convention. Until about 15 years ago, there was an open debate about whether you could sue a country at the International Court of Justice for committing genocide rather than just violating the Genocide Convention. The Genocide Convention has a number of obligations on states to enact legislation for genocide, to punish genocide, to cooperate in extradition. And so there was one theory that was quite, widespread, that all that the litigation before the International Court of Justice could involve was an allegation that the state had not fulfilled their obligations under the Genocide Convention. And in 2007, in a judgment, one of the ones that came from Yugoslavia, most of them have something to do with Yugoslavia, of the 17. So this was the one that Bosnia filed against Serbia. And in that decision, the court ruled that it was possible for a state to commit genocide, although they didn't convict. It's not an international law term, but they didn't hold Serbia responsible for committing genocide. They held Serbia responsible for failing to prevent genocide in Bosnia and Herzegovina. I won't go into the details on all of that. This is really just to situate this current case. The idea that you could hold a state violation of the Genocide Convention. That's a violation of international law to fail to prevent genocide in another country. Was established by the International Court of Justice in the case in the Serbia Bosnia versus Serbia case in 2007, and that principle is the basis of some litigation in the United States that's ongoing, and in which I have a small piece of that. This is a case filed by the Center for Constitutional Rights, which is an NGO, human rights litigation, public interest litigation in the United States, very well established, very professional. And they filed a case against Biden, Blinken, and what's the guy who went to the hospital? Austin. Yeah, Austin. The guy who goes to the hospital without telling anyone. Yeah. Those three, but essentially against the US government for failure to prevent genocide in Gaza. And I did an expert report for that, for them on that litigation, based on the idea, because the obligation to prevent genocide arises when there's a serious risk of genocide. So it doesn't involve a determination that genocide has been committed, but that there's a serious risk. And so I filed a report last October or early November in that case, and it's going for a hearing next week, the end of the week next week, the 31st, I think. Or is it Friday of this week? Maybe it's Friday of this week in Oakland, California. Don't ask me why.
Friday, yeah.
It's this Friday. Yeah. I don't understand I don't know enough about how the US courts and law work to know exactly how that's going to pan out. It seems to me that it would be pretty stunning if a court in Oakland, California were to find that the President of the United States and the Secretary of State and the Minister of Defense were guilty of violating the Genocide Convention, but we shall see what happens. And then the other case in which I'm a spectator at this point, this is the case that was filed at the International Court of Justice at the end of December by South Africa. It resembles another case that was filed about 4 years ago by the Gambia against Myanmar in a number of respects. And we're all tracking it, and particularly this recent hearing and the expected decision of the court in the next week or two. It would seem that it's likely to be similar to what happened in the Gambia versus Myanmar case. So Gambia versus Myanmar filed in November of 2019. And what Gambia alleged was that Myanmar had committed genocide mainly in 2017, 2018. This was the first time a state had taken a case to the International Court of Justice under the Genocide Convention where they were not an injured state, another term of art that we use in international law. A state that was not a victim of the violation of the Genocide Convention, but rather was simply taking up global interest in the enforcement of the convention. And in the case of Gambia, they did it very visibly and very publicly on behalf of the Organization of the Islamic Conference, which had taken the decision to do this and had also raised the money for it. I don't remember how many members there are, somewhere between 50 and 60 member states of the Organization of the Islamic Conference. And so they took that initiative, and that has now passed through two stages of litigation. The first was the provisional measures stage, which happens very quickly after the filing of the application, and then the admissibility and jurisdiction phase, which was completed late in 2023, I think in August or September, with the ruling of the court that rejected the objections to jurisdiction and admissibility that Myanmar had filed. And so that case is now on track for a hearing on the merits. I think that the court has invited both sides to have another round of submissions. They don't do that in every case, but sometimes they do. And in the Gambia case, the Gambia against Myanmar, the court has already received the submissions, I guess, of both sides, and they're asking now for another round of submission. So it's another year and a half away before there'll be an oral hearing of the case, and then perhaps 6 months for a judgment. So now we're in 2024, probably 2026, we'll have that on the merits. The latest development in that case is a filing by a number of other states, including Canada, and I think 5 Western European states, France, Germany, Netherlands, Denmark, there might be one other, where they argue they're intervening clearly in support of the Gambia and against Myanmar, and where they argue for an enlarged, expansive, and liberal interpretation of the Genocide Convention. I bet that the lawyers in Ottawa are regretting that they did that, because in the current proceedings that South Africa filed against Israel, that legal opinion is, let's just say, more helpful to South Africa than it is to Israel. Now, will the court follow it? It's hard to say, but it will tie the hands of Canada and Germany and others who will be tempted to intervene. They obviously can't contradict themselves, because the intervention, although it's a unilateral act of a state, has legal consequences according to the statute of the International Court of Justice, because it means that the state, first of all, they've set out their opinion in the submission that they make, and they have also then agreed to be bound by the ruling, even though they're not parties to the case. It's a peculiarity of Article 63 of the Statute of the International Court of Justice. And these interventions it's a totally new phenomenon. This is a court that's been in existence for more than 70 years. It's more than 75 years. And it's only in the last few years that we've had interventions. So I think there were a couple of them. New Zealand intervened in one dealing with whaling. There were 1 or 2 other examples, but they're pretty obscure. And all of a sudden, this phenomenon began maybe with the Ukraine case. So this is the other. There are 3 genocide cases now. I haven't talked about the Ukraine case because it's a bit odd. It's a bit odd because it's not about an allegation of genocide. It's about an allegation of making an allegation of genocide. It's the claim by Ukraine that Russia has made a false allegation of genocide. It's very unusual. Those of you, you don't usually go to court asking the judge saying, I'm coming to court because I want you to declare that I've, respected the law, and that someone said I was violating the law, and I want you to tell them to stop. It's an odd phenomenon, but it's before the court, and they obtained a provisional measures order 2 years ago, in February of 2022, against Russia, including one that Russia was to stop the invasion, and Russia has not complied with the order of the International Court of Justice. That case is at the admissibility and jurisdiction stage. The case was argued in September of 2023, and we're waiting for a ruling as well. It wouldn't surprise me, because that ruling is due. They're ready for it, and the judges are about to have a turnover where 4 of them are going to leave and be replaced by 4 new judges. So they have to kind of tidy up the work at the court, and it seems likely that in the next few weeks we're going to have a ruling both in the Ukraine case on the admissibility and jurisdiction, and the ruling on the application for the order of provisional measures in the case filed by South Africa at the end of December. So let me turn now to a little bit the details of the case filed by South Africa against Israel. There's been discussion since October about taking a case to the International Court of Justice. There have been, of course, allegations of genocide. There have been allegations of genocide on both sides, by the way, and in the hearing a week and a half ago, Counsel for Israel accused They didn't accuse South Africa of committing genocide, although they accused them of being accomplices to genocide because they said they were sympathetic to Hamas. Now, that's an interesting legal problem because I don't know how much of your criminal law you remember, but you don't become an accomplice to a crime just because you sympathize with someone who's committed it, even if you did sympathize with them. Even if that's true, it doesn't make you an accomplice. But those allegations were made in the oral hearing. It's been obvious to me since October of last year that it was tactically a very interesting move for either Palestine or supporters of Palestine to take a case under the Genocide Convention because of the likelihood that they could get a provisional measures order. This is the case that happened with Gambia and Myanmar 4 years ago. It's a very low threshold to get an order of provisional measures at the International Court of Justice. All that you need to establish is that you have a plausible. It's a little more complicated than that. There are a number of separate questions. It's like an interim injunction. That's what you call it here in Ontario, an interim injunction. And to get an interim injunction, you have to demonstrate that you have a prima facie case or something like that, and that it's urgent, and so on. But one of the differences between what they do at the International Court of Justice, and this is what they did in the Myanmar case, is that they will order you to respect the Genocide Convention. I think it's quite likely that the International Court of Justice will order Israel to respect the Genocide Convention. Now, if you were a lawyer for Israel, you might be inclined to answer saying, well, that's cool, because we do respect it. This is what they did with Myanmar in an order in January of the year 2020. My experience, I used to practice law in Canada, not here, but in Quebec. I used to go and get provisional orders, often in family cases. But I never went before a judge and said, I want you to give an order again to that guy not to beat his wife. The judge would laugh you out of his office and say, we don't order people to obey the law. They have to obey the law. You get an interim order, generally, I think, to order someone to do something that they're lawfully entitled to do. So we get them, for example, at the European Court of Human Rights, ordering a state not to extradite someone where they'd be subject to torture or the death penalty. And why is that? Because otherwise they're legally empowered to extradite them or to expel them and send them to another country. So you need an order of the court because otherwise they're complying with the law. But at the International Court of Justice, they issue these orders that are really quite, they seem almost anodyne. They're not, it's an order to obey the law. But in the case of Myanmar, they were ordered to do it, and that it was hailed around the world as a defeat for Myanmar and a victory for the Gambia. So I think that's what will happen in this case as well. So that even if it's, in other words, it's it can be a symbolic kind of order. Now, it can be a more demanding order as well. And here the great example is the order that was directed at Russia with regard to Ukraine, where they ordered them to stop the invasion. And South Africa, one of the requests that it's made is an order for the military activity in Gaza to cease. If South Africa gets that, then they have scored big time at the court. This would be a big victory for South Africa. But there are a range of possibilities, somewhere between an order to Israel to respect the Genocide Convention and an order to stop all military activity. And we'll just have to wait and see what the court will come up with. Very difficult to predict. Very difficult to predict the content, I think, of the order that's likely to result. I think it's quite easy to predict the fact that there will be an order. In other words, that South Africa will succeed. And my impression, I guess many of you must have watched parts of the hearing as well. I almost had the impression that Israel wasn't really, they had recognized that these are pretty difficult requests to fight off. And so a lot of Israel's submissions were more directed at the public in general, the public in Israel, and presenting arguments that are not really that relevant legally, not getting to the heart of the issues, arguing about what happened on the 7th of October. It's almost irrelevant, seems to me, to the issue of the provisional measures order, but a great deal of attention was devoted to it, and relatively little attention to the main issue that's I think, that's in dispute, and that is the extent of what the order would be. So Christopher Staker was, the very end of the hearing, he had 15 or 20 minutes, as I recall, where he spoke about that facet of the case, but it wasn't very significant. So this is the case. Now, on the merits, we have two big judgments of the International Court of Justice on the Genocide Convention. One in 2007 in the case of Bosnia versus Serbia, and the other in 2015 in the case of Croatia versus Serbia. I should say, just as an aside, I've been involved in two of these three cases. So I was counsel to Croatia, to Serbia in the Croatia case. And that involved not only the Serbia was acting in defense to the charge of genocide, but also they had a counterclaim against Croatia, charging Croatia with genocide, and both the application and the counterclaim were dismissed in the judgment in 2015. I wasn't involved directly in the case in 2007, which was between Bosnia and Serbia. And there too, the charge of genocide against Serbia was dismissed. And what the court did in that case was it basically adopted the decisions and the conclusions of the trials at the International Criminal Tribunal for the former Yugoslavia. International Criminal Tribunal had made a number of rulings about genocide, some of them dismissing them, and in the Srebrenica cases, recognizing that genocide had taken place during a very brief period in 1995, in July, about 4 or 5 days, which it characterized as genocide. And so the International Court of Justice basically adopted that and then ruled that Serbia had failed to prevent the genocide in Srebrenica, although it didn't hold Serbia responsible for the genocide. They said you have influence on the Bosnian Serbs, and you didn't use it. You didn't address it. In both those cases, the court adopted quite a strict interpretation of the Genocide Convention. So it excluded what it excluded from it was manifestations of what we call ethnic cleansing. Ethnic cleansing is barely a legal concept. It does exist in General Assembly resolutions, but there's no treaty definition. It's not in the Rome Statute. It's not recognized as an international crime. But roughly speaking, the court made a distinction between what it called measures intended to physically exterminate a group and measures to expel a group from a territory. And it said that's not genocide. It drew a line and said that was not covered by the Genocide Convention. So the massacre of Srebrenica involved totally annihilating the men of a community in part of eastern Bosnia. And so they said that was genocide. But the measures of expulsion of populations involving tens, in one case, 100,000 people in Bosnia and Herzegovina, they said that's not genocide. And the consequence of that, of course, at the International Court of Justice is that they dismissed the case. This is not a situation where they can run it down a notch and say it's not genocide, but we're going to find you responsible for a lower level of violation of international law. The basis of the jurisdiction of the court is genocide. So if it's not genocide, it's done. It's dismissed. And that's what they've done. So it's been criticized for before and after. And the most recent example of a criticism of that view, although it's not presented as a criticism of the view, but it certainly is the submission by Canada and the Western European states that was filed in November of 2023, arguing for a broader approach. My assessment is that this issue is it's an open issue. That's all we can say. I think that the fact that these countries, it doesn't change the court. They obviously depend on the decision of the judges. But we can't rule out, certainly can't rule out the fact that the possibility that the judges of the International Court of Justice will adopt a broader, more generous understanding of genocide. And if they do, that will, as I say, be favorable to the South African side of the debate and unfavorable to the Israeli side. I heard, you can see it on the European Society of International Law website, there was a panel discussion, and Marko Milanovic, who is a very distinguished international lawyer at the University of Reading, spoke about this. And Marko said, if they follow the two decisions in the former Yugoslavia, Israel will win on the merits. This is 4 years from now. So that, if he's correct in that assessment, that just means the question is whether the judges of the court are going to adopt a different perspective. It's a court that is constantly changing. The composition is changing. There will be 4 new judges who take over in a few weeks at the court. And even the ones who remain have been, there won't be any of them who were left who were there in 2015, or maybe a few. But it will be a rather dramatic turnover by the time we get to the merits, likely get to the merits first in the case filed against Myanmar, and then in the case against Israel. There's an interim phase of objections to jurisdiction and admissibility, and I think that's going to be quite a fight. That will take place perhaps in a year and a half. The hearing, at any rate. Once the provisional measures order is issued, probably the same day that it's issued, the president of the court will set the date for the submission of the memorial by South Africa. Probably 6 months, approximately, maybe 8 months, something like that. There will be an order to South Africa to make its full submissions. People ask, of course, people have read the application, which is on the lengthy application, 80-odd pages. And they say, well, so what do you think of South Africa's case? And I answer, well, it's not the case yet, actually. The case will be in the memorial. And it will be much more elaborate and much more extensive. What the application is more like a demand letter. It's starting the case, and it's opening the door for this first phase of the provisional measures. But South Africa will file its full case within 6-8 months, whatever the deadline is that's set by the president of the court. As I say, probably in the next week or two. And then once that's filed, I think it's a 3-month delay that Israel will have to make its objections to jurisdiction and admissibility. So we had a bit of a taste of this in the pleadings a week and a half ago, particularly when Israel said, well, there's not a dispute. So this is a very classic objection to admissibility of a case where the respondent state says there's not a dispute. And the court has in the past, on occasion, dismissed applications because they've said you essentially what the philosophy of it is that states are supposed to try and settle their disputes amicably. And when they don't, then they can come to the court, but they have to be able to demonstrate to the court that they've tried to resolve the dispute before they come to the court. And there was a case filed by Georgia against Russia 15 years ago under the Racial Discrimination Convention, and the court dismissed it on the basis of claiming that Georgia had not exhausted, had not fulfilled the duty to attempt to resolve the dispute amicably. And so they said, we don't know if there's a dispute. Yeah, there has to be a dispute. So Israel raised that argument. It's again, to me, there are a few features of it that make it, again, hard to assess how the court will react to it. The first is that the nature, this very unusual, unprecedented, really, or almost unprecedented aspect of a state that's not injured filing the case. What's the dispute exactly between the two states then? Because it's really a state acting for the international community saying, well, you're violating the convention, and we've told you a few times that you're violating the convention, but it's not a kind of dispute like a bilateral dispute where the two states can compromise a little bit, give a little bit here. There's nothing that South Africa wants from Israel resolve a dispute. So it seems to me that the philosophy behind this idea of negotiating a solution to the dispute, when it's a boundary dispute, okay, we'll give you that island and you can have that fishing zone, kind of, they can work out an agreement. But here I don't see where the room is to resolve it. The same objection was made by Myanmar against the Gambia, and it was dismissed. So but that's an argument that will arise, and it leaves open the possibility that the case could be thrown out before it gets to that stage. The interventions, states have made statements saying they're going to, third states have said they're going to intervene in the proceedings. I think this is not always well understood either, exactly what's involved. The statute of the court says that states that are parties to the treaty can intervene. The idea here is that if there's a treaty in dispute and it's a multilateral treaty, it's not just the two states that are fighting the case that are affected by the decision. And so the statute of the court says that when it's a multilateral treaty, the registrar of the court sends out a notice to all states parties. They don't really need a notice. They can read their email, but technically they get a letter from the registrar saying, you are invited to make submissions about the interpretation of the treaty. It's not an intervention where they come and say, we support that side. But last week or 2 weeks ago, Germany said, we're going to intervene to support Israel in the case. You can't intervene. Technically, you can't. Now, the court has yet to really rule on that aspect because they've never really had these interventions until very recently. They had more than 30 of them in the Ukraine case. All of them were from one little part of the world known as Europe. Well, Canada and the United States intervened as well. But essentially, it was Ukraine's friends intervening to support Ukraine. And they were, a lot of it wasn't even legal arguments. It was just cheerleading for Ukraine. Frankly, they weren't making legal arguments in many cases. They were just saying, we agree with Ukraine. We agree this case is admissible. And often you could read I've studied the submissions, as I say, more than 30 of them. I don't want to say they were written by ChatGPT, but the language is very similar in many of the submissions. Sometimes there was a lot of copy pasting going on there in the preparation of these submissions. And the court already indicated that it's not actually thrilled about these submissions because it did make a ruling on the admissibility of them and said some of you are going way beyond what you're supposed to be doing. You're supposed to be talking about the interpretation of the treaty. So it's going to be interesting to see, what interventions we may get in this case. First, because the court may start tightening getting a little more rigorous about what it admits and telling states, listen, this is supposed to be about the interpretation of the Genocide Convention and not about whether or not you're in favor of Israel or you're in favor of South Africa. And so we'll see how that plays out. There are definitely going to be more interventions, and it's hard to know how many. In the activist community, people who've been campaigning for this, they're trying to get states to intervene on the side of South Africa. But I think that when the lawyers in those governments look at it and look at how the court has reacted in the Ukraine case, that maybe it'll be more subdued, the types of interventions, because they will be focused on the interpretation. And this is going to be really interesting, because the core issue, as in the Myanmar case, is about whether we adopt a broader or a narrower interpretation of genocide. It's almost as if we're renegotiating the convention, the Genocide Convention, and everyone agrees that it was drafted quite strictly in the definition. It's very narrow, and it was drafted strictly in 1948. It's strict because it's focused on 4 categories of groups: national, ethnic, racial, and religious. But it's also strict because it requires, it's certainly been interpreted this way, the physical destruction of the group. And the idea that states say, let's open that up a little bit. But they may not all be enthusiastic about doing that, because it's going to expose them. The broader the definition is, the more exposed they will all be to being themselves taken to the International Court of Justice. So I think I'll stop in just a minute. I'll just say now, so the next phase, first of all, we'll have the order in the next, I think, probably 2 weeks on this. As I say, I'm predicting, I think it's not difficult to forecast that there will be an order somewhere probably in between the minimal idea of ordering Israel to respect the Genocide Convention. This is one other thing. In most of the previous orders, they order both sides to behave themselves. But what's the order of South Africa? They're not involved. There's nothing to order. And so this is one of the curious features of it as well. Israel says there's another side, but the other side isn't actually there in the court. They're not a party to the proceeding. We'll have to wait and see if Palestine, the state of Palestine, intervenes in the proceeding. I think that Palestine was probably reluctant itself to take the case for 2 reasons. One is that it would then provoke a big dispute with Israel about whether or not Palestine is properly a state party to the Genocide Convention. That's an issue that has been settled in a sense, but has not been decided, ruled on by the court, and there would be a big fight about that. So I think that, that's probably the first part of it. The second part of it is that there's another dispute about Palestine coming before the court next month, and this is the advisory opinion proceedings. So the International Court of Justice has 2 types of cases. It has contentious cases between states. That's what the South Africa Israel case is. And then it has advisory opinions, which are much rarer. There have been, I don't know, 15 or 20 in the history of the International Court of Justice since 1946. And of those 20, 5 of them were about Namibia. So it's quite unusual. And now all of a sudden, it's the other thing that's happening at the International Court of Justice. We have 3 applications before the court. We have one on climate change. I think you're involved in this, right? A little bit, maybe.
We are filing submissions.
Yeah. So there's one on climate change. There's one on the right to strike that was requested only very recently, and there's one on Palestine, which is round 2, because there was an advisory opinion on Palestine about the wall back in 2004 that ruled against. Advisory opinions don't rule against anybody, but in practice they do. The British are still smarting from being found, from losing the Chagos Islands case 5 years ago at the International Court of Justice in an advisory opinion proceeding. So this is coming up as well next month. So I think that maybe made Palestine, the state of Palestine, nervous about taking its own case there, and so they've got South Africa. I didn't say a word. The relationship, the South Africa's role is fascinating. I mean, it's almost like a film script, because South Africa, of course, has been at the International Court of Justice so many times in the past about apartheid before 1990. And also, South Africa had at one time was Israel's greatest friend for about 20 years between the late 1960s and the end of the 1980s. They were the best of friends. Actually, South Africa was about the only friend, one of the few friends that Israel had, and Israel was one of the very few friends that South Africa had. And so they had this road, but that obviously came to an end with the end of apartheid in South Africa. Yes, I will stop now.
That's great. Thanks so much. So I just want to say it's just such a rare and wonderful experience to get this access to this level of expertise on what really is probably right now the most hottest and most current sort of topic in international law. And I just want to, we were going to open it up for Q&A in a few moments, but I just want to, before that, sort of jump in and use my prerogative as the chair of this event to ask my own sort of like personal questions out of my own curiosity. I think the first one I want to ask, I want to dig into the law on genocide a little bit. You may say you are the world's leading expert. So genocide, as you know, like any sort of criminal offense, has various elements. And like any criminal offense, there's a physical act element and a mental element. And unlike certain other offenses like crimes against humanity, there's no chapeau. There's not really a contextual element. It says nothing about numbers, I guess, is what I'm getting at. So in theory, you can have one person commit an act with the requisite mental intent that victimizes just one other person, and that could, in theory, be genocide. But I'm just asking, does that sort of like, because that is something that could very well happen in a wide range of armed conflict around the world. So I don't know. It does something about that perhaps sort of impact or even sort of like dilute the effectiveness of genocide, the fact that it's something that could in theory sort of like happen in all kinds of different contexts. It doesn't necessarily, there's no contextual requirement of like it occurring sort of like in a larger broader context of similar conduct according to the convention.
That's a good question, James. It's a good question. And I guess pretty much everybody here either has a law degree or is in the course of getting one. Am I right? Yeah. I mean, if it was a general public, I'd be a little more, I want to dive into the technical legal stuff here. The definition is in the Convention of 1948, and you're quite right. It doesn't have those contextual elements that we have with, for example, crimes against humanity, which talks about a widespread or systematic attack. Genocide, the focus is not on that contextual part, but on what we call the specific intent. It's just the peculiarities of how it was drafted. And also because when the Genocide Convention was drafted, there was not a lot of experience in defining these crimes, and it was drafted by, it's drafted by a committee. So you get weird things as well. The definition of genocide in the convention has been repeated over and over again. And unlike the other categories of international crimes, the big three, genocide, crimes against humanity, and war crimes, every time war crimes get defined, it's different. There's a huge evolution in the definition of war crimes. For example, in the Rome Statute of the International Criminal Court, which was adopted in 1998, and what war crimes were thought to be in Nuremberg. Huge expansion. The same with crimes against humanity. Genocide sort of stood still. And the definition of 1948 gets repeated again and again, and it gets largely repeated also because this is international law, but at the domestic level in domestic legislation. So we have it in the War Crimes and Crimes Against Humanity Act in Canada, a definition of genocide that departs slightly from what's in the Genocide Convention, because it talks about genocide directed against a national, ethnic, racial, religious group or other groups that might be recognized by customary international law. I don't remember the exact wording, but they leave open that possibility of expanding the definition. And many other countries have done, it gets before a parliamentary committee and you have some parliamentarian that says, couldn't we improve on this? So you have a lot of little small variation. But the big development in the international sphere is when the Rome Statute of the International Criminal Court was adopted. They adopted the statute and took the definition from the convention. But they also allowed in the Rome Statute for something called the elements of crimes, which is a separate legal instrument. It's a separate document that was not adopted in 1998, but was adopted in the few years that followed. So for every crime listed in the Rome Statute, you have this element document which expands on them a little bit. When I say expands, I mean just tries to explain a little bit more about what is meant. So an example, a rather banal example, is you have the crime against the crime of genocide of forcibly transferring children from one group to another. They don't define children. Okay? The Genocide Convention doesn't. So what's a children? What's a child? And so that's in the elements of crimes, someone under 18. Okay? They resolve that. And that's law that's binding at the International Criminal Court. But I dare say if you had a genocide prosecution in Canada where the crime was based on forcibly transferring children from one group to another, the prosecutor would come and say, here are the elements of crimes, Your Honor. I think we should follow that. That's an authoritative explanation. And of course, the elements of crimes were adopted by not just the members of the International Criminal Court, but also by all the states that participated in drafting the Rome Statute. So that includes Russia and China and the United States and Israel and India and all the others who haven't joined the International Criminal Court participated in that. So it's very authoritative. With genocide, they also added a contextual element, which talks about a manifest pattern of similar acts. So they add something very not equivalent to what we have for crimes against humanity, but they address that problem there. But here's the thing. If you were to have a prosecution in Canada of someone for murdering a single person, and they say he had the genocidal intent and he killed one person, so he's guilty of genocide, the defense lawyer would say, Your Honor, have a look at the elements of crimes. The prosecutor would say, they're garbage, the elements of crimes. That's what's going to happen. You're not going to have that debate at the International Criminal Court because they're bound by that. It will be raised, no doubt, in the litigation at the International Court of Justice. It's going to be interesting to see what they come up with.
Great. Thanks, Professor Shibas. My next question is also going to delve into the law a little bit, also about the requisite intent element of genocide, which is and I might get one or two words wrong, but it's the intent to destroy or whole or in part a population. And when we talk about intent, obviously, intent is something that people have, that individuals have. When we talk about states committing genocide, states don't have an intent, right? States are abstract entities. So how you explain to us how a state can be held liable for committing something, one of whose principal elements is an element of intent that only humans can have.
This is something, there's a lot that's been written and sort of speculation on this. It was easier at the criminal tribunals because you had individuals who were being prosecuted. But you're quite right, when it's a state, how does the state have an intent? We resolve that, crimes against humanity, by requiring a policy. And we have a requirement in the Rome Statute of a policy for crimes against humanity. But it's not so straightforward with genocide. And again, that contextual element, a manifest pattern of similar acts, suggests a policy element as well. But the intent is the real, it's the most difficult part in a way of the definition of genocide. It's not so much about requiring the intent as the threshold. It's a specific intent. So I don't know if you remember all this from your criminal law course, but the the handful of crimes that we say have a specific intent, and like murder, for example, and the specific intent makes it more difficult to demonstrate the intent, or it makes it easier to defend when you're charged with such a crime, where the evidence of the intent is based on an inference based on conduct. So when it's an ordinary crime with general intent, we simply say people are deemed to intend the consequences of their acts. And in a criminal court, we don't prove the intent. It's for the defendant to come and say, I didn't have the intent. I was drunk, I was crazy, I was forced to do it, I was acting in self-defense, all of these things which can address, respond to the charge. But absent a defense, the court will deem that you intended to do what you did. But it's not so simple when it's a specific intent, because you draw inferences from conduct, and you have to be able to eliminate all other reasonable explanations for the conduct. It's kind of like the rule of circumstantial evidence. You have to be able to say, there's no other reasonable explanation for why the person did that, so it's appropriate to conclude that they had that specific intent. Some of that was being debated 2 weeks ago in The Hague. And that was, a lot of attention was given to the statements. So you had some terrible statements by Israeli politicians. And it was interesting that the lawyers for Israel kind of tried to distance themselves with some of that. I said, well, he's not a decision maker, not an important minister. And they did some of that, which was in a way acknowledging that this is not, it wasn't very appropriate, those statements, to say the least. I don't know how important that's going to be. You have, in other cases, the criminal cases that were filed, and you had it in the Croatia case as well. You had evidence of such statements. You have it in the Myanmar case, not as much, nothing compared to what we have recently from Israel. The judges have tended to, it's not irrelevant. I don't mean to say that this is not of no significance, but they tend to emphasize deeds more than words, actions rather than words. And the words are, there's a tendency to say, these are hotheads, they make crazy statements, but let's look at what they're doing. And that's but there's a feeling that those statements indicate the intent. But as I say, to me, you're looking for a policy. To win the case, you want to show that there's policy at work, and you do that by demonstrating the conduct, saying this is how we identify if you want, the intent of the state. We look at what they've done and we say there must be a policy behind it. And even if they say it's another policy, actually that only points in one direction, so that's what the policy is. I think in this case, I think that the policy argument has become stronger, because my impression, and I haven't really talked about the merits of the case here, but my impression in the conflict that's been going on since the beginning of October is that the alleged policy of Israel, which was to defeat Hamas and to free the hostages, is actually not what they seem to be doing. And that the real policy at work is crush the Palestinians, destroy their home, scorched earth, so that they won't come back. They can never come back. And because I think that if they were out there ready to defeat Hamas, there'd be a lot more casualties. I think they're not taking the casualties. I think the numbers are still in the hundreds of soldiers who've been killed, and don't want to see anybody get killed myself. But if you want to defeat or try to defeat Hamas, you've got to go in there and fight in the ruins of these cities and into the tunnels, and otherwise they won't even come close to defeating them. I think they've freed one hostage since it started. I mean, lots of hostages were freed by negotiation, but militarily, think there's only one hostage who was actually freed. There were the three others who got killed. Yeah, they were killed because they thought they were Palestinians, who you could kill with a white flag. Yeah. So
Great. So I want to sort of now shift to talking about some of the implications of the case of the ICJ. And I want to ask if you could talk a little bit about potential implications and ramifications for third-party states, states like Canada, in terms of what their obligations may be after any sort of theoretical provisional measures order, recognizing that, as you said, it's very difficult to forecast what that order may contain.
yeah, I think for Israel that they may decide if the order is very modest, they might even strategically decide that it's better to just say that's fine, we can handle that, and not be dismissive of it. If it's more demanding, for example, an order that they have to provide, as South Africa's requested, unimpeded access to food, medicine, and so on, this will be more, they're more likely to be defiant. And the problem with that is it's not, Israel will be defiant, and that's probably to be expected. And the United States is unlikely to be terribly exercised about that. The decision on, I don't know if everyone remembers this, the decision at the International Court of Justice on the binding nature of provisional measures orders, because for a long time it was disputed that they were binding, that you could have a binding order, was in an American case, a case filed by Germany and then another one by Mexico against the United States about the consular notification to people on death row or people suspected of capital crimes. And so that was an order against the United States, which the United States didn't really respect. And the court said, but these are binding orders. But it will make it very awkward for countries like Canada, who are much more devoted to the court. Middle powers, understandably, the most powerful military power in the world, the United States, figures, court, what the hell, we can handle that. And they're not proper members, but countries like Canada and Germany and even France are much more attached to the court, and they're there. So Canada took a case against Syria with the Netherlands. Canada has to be fully respectful of the court, and I expect that to be the case. And I think they've said that. I think they've said we will respect what the court decides, which is entirely appropriate. I think that, I don't know if it was the minister here or the prime minister who said initially saying, well, we don't think that South Africa has a strong case. My own view is that if you're really respectful of the court, you just stand back and say, we'll see what they decide. We don't. It's now before the court, and we respect that court so much that we're just going to wait and see what they decide, instead of trying to weigh in and say, well, we don't like that side or we don't agree with that. Let's just wait and see. I think that's the appropriate. But Canada and Germany didn't take that view. Germany got its knuckles wrapped. I guess you saw that from Namibia. Told them that it's not a good look for Germany to be denying genocide. Have a little experience with the subject.
And on this topic of powerful countries ignoring orders of the International Court of Justice, a lot of critics of international law and of the International Court of Justice raise that, and they point to that, and the fact that, as you also said, Israel could just ignore the order, and as long as its allies, such as the U.S., behind it, nothing would really happen to them. And a lot of critics of international law point to that as basis for an argument that international law and the international legal system aren't very effective. So what do you say to people who argue that international law and the international legal system were designed by the global powers and imposed on the rest of the world in order to entrench their own interests, and can't really be effectively used as a tool against those same interests?
Well, people say, international law. The problem with it is it's too political. They want to be, they're more comfortable in a nice, tame civil court in a country like Canada where judges are independent. And international law, it's a mix of law and politics. There's no doubt about it. And the International Court of Justice is a place where politics and law get mixed. I think that's what I love about it. I think that's why I'm so fascinated by it. It is this mixture. The International Court of Justice has its own fascinating history this way in terms of its own credibility and the willingness of states to go before it. There are now 23 or 24 cases before the International Court of Justice. There have never been so many cases because states obviously think that it is a place to go. They wouldn't waste their money and their time if they thought that it was just a waste of energy. But they go there, and they're more than ever. They're going there. Why is Canada going there against Syria? They obviously think something can be achieved there and accomplished. So, it's the problem with the big powers. The first case at the International Court of Justice was filed by the UK. The first contentious case by the United Kingdom against Albania back in the 1940s. Some of you remember this maybe from your international law course, the Corfu Channel case. Corfu Channel, it's the little strait between Albania and Corfu. And I had the pleasure last August of swimming the Corfu Channel, 3.5 kilometers. I did it with 2 other international law professors.
Wow. What has been in your introductions?
So the Corfu Channel case, the UK said, we're going to sue Albania, little pipsqueak Albania there against, the British Empire. This is 1947. And Albania said, well, we don't even have to come because they weren't even members of the UN. But they said, but we'll go to court as long as we can sue you back. They couldn't object. So the court ruled against both sides, finally, and they ruled against the British for violating Albania's sovereignty. And people around countries around the world said, well, that's amazing that the world court controlled by the British Empire could rule against the United Kingdom. Astonishing. And they started going to the court, including Israel. Israel went to the court as well very early in, I think, 1955, about a plane crash or something. So then in the mid-60s, they had a terrible ruling at the court when 2 African states, there were only then in the beginning of the 60s, still only a few African members of the United Nations. These were the 2 states that had been members of the League of Nations, 2 African states, Liberia and Ethiopia. And they went against South Africa because South Africa was still occupying Southwest Africa, Namibia. And the tying vote of the judge, the Australian judge in the court, threw the case out. And it was terrible. And it destroyed the court for decades. I went back and looked at this recently because I like telling the story. Lester Pearson in Canada, in the General Assembly, condemned the decision when it came out. And there were new elections and new judges got elected, and the court gradually recovered its reputation. And the turning point was in the mid-'80s when Nicaragua sued the United States of America and won. Concrete state withdrew their reservations to the jurisdiction of the court, and they said, well, this is a court that we trust. And so it's capable of doing things with a if the countries of the South win a resolution in the Human Rights Council or even in the General Assembly, people say, well, okay, but they outnumber us, this happens. But when they lose a case, when the countries of the global North lose a case in the International Court of Justice, and that happens, it's a very powerful message. Even if it doesn't bite legally, you can't then give the judgment to the bailiff and go and say seize their bank account or something. You can't do that. But it's not to be dismissed. I think the British lost this case, an advisory opinion about the Chagos Islands. It was a tremendous decision, and they fought bitterly to prevent it. And no, I wouldn't be, but it's not like suing someone on a check and then going and getting the bailiff and seizing their bank account. It's not like that. It's politics and law mixed together.
Great. And so for my last question to you, I just want to shift gears a little bit and talk about how a lot of students have that I've spoken to have talked about how there's a lot of fear and nervousness about speaking up and voicing their opinions in the current climate. And just as an example, I mean, you need only look at another law school across town here, where some students came out with a statement a few months ago and got condemned by a lot of lawyers and law firms who didn't want to hire them, and that their own administration actually went and piled on and condemned the students vigorously, and now have launched an investigation into the students. So there's a lot of fear about like attacks like that by lawyers, their own administration, and that sort of thing. And just the fact that we hastily pulled this event together a few days ago. Just this morning, I was talking with a colleague thinking, are people going to show up? Did we order too much food for 30 people? And we ended up filling the room. And I think that tells you suggests to you how few opportunities there have been to have some kind of like open dialogue and discussion. And part of that is this atmosphere of fear that's been cultivated. And I bring this up because a lot of people may not know this in this room. Everyone knows you're, this leading expert on the law of genocide. A lot of people may not know that you actually have a lot of experience with facing retribution for campus activism. And this year marks the 50-year anniversary of back in 1974. You were actually expelled. You were a student here at the U of T. You were expelled for your campus activism. And I just wanted to ask you if you could share some of your thoughts and reflections on that experience, and particularly, what its impact was for you, whether it ruined your life or whether you were able to move on a little bit and get over it, and sort of what the implications are for students who as someone who faced probably the most severe sanction an academic institution can impose, expulsion. Maybe share your reflections on what your experience might mean, what insights you have for students who sort of like face fears about voicing their opinions in the current climate today.
I don't often get asked questions like that. And I haven't spoken about my past at the University of Toronto, which was 50 years ago, for more, probably 50 years, seriously, and above all to be here. Yesterday afternoon, I saw Martin Friedland. People know him. He's a retired professor here at the university. I'm sorry? Criminal law. Yeah. And one of the great scholars of this law faculty. And he wrote the history of the University of Toronto. And he has a chapter where not about me, but he talks about, he has a chapter, it's a history of the University of Toronto. And there's a chapter about the activism of the 60s and 70s at the university, and the little part I played in that. You see other people. You see Bob Ray, who's very well behaved, and still is today. Smoking a pipe, I think there's a picture of him there, and Michael Ignatieff and others. And so, but I was on the more radical side than those guys. Obviously, no one came and asked me to be the leader of the Liberal Party. I wondered, catering is fine. I thought there'd be security. Maybe there are, because I've been at such events and you see people who you don't recognize who happen to be there, and sometimes they have little wires in their ears, and the universities are very, very, it's terrible. In the UK, where I live and work, it's terrible as well, the universities. And don't think it's just the students who are being picked on, it's the faculty as well. A lot of faculty are terrified about it. And I'm in now a pretty safe position because of my age. And, if I'm, even if they fired me, it's not a big deal, really. No, seriously, I don't have big career that I'm worried about or anything like that. I have my pension, I can live without the university. But I sympathize with my younger colleagues who are facing this, and they're just like students, although they're not worried about getting an articling position or something like that, but they're worried about getting a promotion and about some sort of invisible blacklist. It's terrible here in the United States, in the UK. Um, Academic freedom, there should be academic freedom for the faculty. This is so important for a university and an environment where students feel really comfortable to express their views about things. I didn't get angry, but I got a little impatient with my students in Paris. I teach at the Sciences Po in Paris as well, and I have a big class there of students in human rights. They're all very enthusiastic about human rights, but and so last October and November, as this crisis was brewing in Gaza, they were very, very concerned about it. We spoke about it a lot in the class. But at one point, they said, well, they even complained that the faculty weren't doing enough. I said, the faculty? I said, you're not doing enough. You should be out there having demonstrations and protesting and taking positions and debating this stuff a lot more than is going on. So, I mean, I congratulate you on holding the meeting. And you said, why did I give up even my few evenings of my grandchildren here in Toronto to come to this? Because I want to be part of it and contribute to it in the way I can to addressing these issues. But yeah, look, you're going to get knocked around a bit. You get bruises, but you just pick yourself up and keep on going. And that's sort of what I did. They don't kill you; they just make you stronger. Getting thrown out of university is not the end of the world. Lots of people have suffered a lot more, gone to jail for long periods of time, been executed, and it's not a big.
Great, not a big deal. You may not. You may not become leader of the Liberal Party, but you'll be. Okay, so I've hugged you long enough. We'll open it up the floor to Q&A. But just before that, let's thank Professor Shamus one last